Thank you. Welcome back to Inquiry into the Workplace Drug Testing in Victoria. Joining us for this last session, we got members from the Mining, Energy and Unions, Mr. Mark Richards and Mr. Adam Jacka. Also joining us is Australian Manufacturing Workers Union, Mr. Tony Piccolo. And also from the Health and Community Service Union, Ms. Stephanie Thuesen. Welcome. Thank you very much for attending. Before I continue, I just want to introduce myself, Chung Lo, the Chair, and Deputy Chair, Mr. Ryan Batchelor, Mr. David Eggershane, and Ms. Rachel Payne, Dr. Sarah Mansfield, Mr. Richard Welch. And also, maybe joining us is also, as I was speaking, Dr. Renee Heath on Zoom as well. Before I continue, I will read this information to you. Regarding the evidence you're providing for us today, all evidence taken is protected by parliamentary privilege, as provided by the Constitution Act 1975 and first subject to the provision of the Legislative Council's standing orders. Therefore, the information you provide during this hearing is protected by law. You're protected against any actions for what you say during this hearing, or if you go elsewhere and repeat the same thing, those comments may not be protected by this privilege. Any deliberate false evidence or misleading of the committee may be considered contempt of Parliament. All evidence is being recorded. You'll be provided a approved version of the transcript following the hearing. The transcript will be obviously made public and posted on the committee website. All my apologies. Also joining us on Zoom is Mr. Lee Tamaras. Lee, would just for record purpose, could please state your full name and the organisation you represent today here, please?
It's Mark Richards. I'm the Mining and Energy Union Representative, State Secretary.
Adam Jacka. I'm a National Legal Officer at the Mining and Energy Union National Office.
Tony Piccolo, Assistant State Secretary, AMWU.
Tony.
Stephanie Thuesen, Health and Community Services Union Projects and Political Liaison.
Again, thank you so much for joining us today and giving us submission and giving me time to give us your insight lesson to this matter of the inquiries. I know you made a submission, but I'll open up to the floor for a brief opening statement from each one of you before we open to the committee for asking questions.
I'll start for the Mining and Energy Union. Firstly, we thank the committee for the opportunity to contribute evidence to the inquiry. In Victoria, the Mining and Energy Union primarily represents workers in the Latrobe Valley's brown coal mining and power sector, as well as across various parts of the state's mining and energy industries. Employers rightly have an obligation to ensure a safe workplace for others. Our members work in dangerous settings, operating heavy machinery and vehicles and working long shifts, so we're very aware of the safety issues that may arise from that. However, and arising from our submissions is our experience has been that employers' social attitudes towards medically prescribed cannabis are out of step with the growing mainstream medical acceptance of medical cannabis, particularly medically prescribed cannabis. Consequently, the MEU members who have been prescribed medical cannabis by their medical practitioner have been disproportionately targeted by employers. As a legal officer for the union, I've represented a number of members who have faced unfair treatment due to their use of medically prescribed cannabis, despite following all the protocols and drug and alcohol policies implemented at their workplace. The same approach has not been taken by employers in the workplace, for example, when managing employees who are prescribed medications such as benzodiazepines and opioids that can also cause impairment and should be treated equally when assessing impairment. Our submission to the committee highlights 3 case studies where workers prescribed medical cannabis have been treated unfairly by employers, including being subject to levels of testing beyond what is usually required by the workplace drug and alcohol policy and being stood down and prevented from attending for work. Some of those conditions included anxiety, insomnia and acute pain. In each case example, the employer either directly or indirectly stated that if the employee continued to take medically prescribed cannabis, their employment was at risk. The other detriment that these employees suffered was that they were required to deplete their leave balances and go onto unpaid leave while they were effectively weaning off the medically prescribed cannabis to go across to some other sort of prescribed medication. They were led to fear for their jobs and had to cease taking the most appropriate medication for them due to the insistence of their employer. These experiences caused anxiety for the workers and exacerbated their medical conditions. We found that these employer actions are driven by a misunderstanding of the use of medically prescribed cannabis, in particular the fact that impairment can be managed appropriately to enable safe attendance at work, just like with any other prescription medication. Employee misunderstanding has been especially pronounced with regard to prescription medical cannabis in the form of CBD, which is a non-intoxicating cannabinoid with therapeutic benefits and value. The TGA has scheduled products involving lower doses of CBD as pharmacist-only medicine. So we're talking about things like you can get analgesics, you can get all sorts of things across the counter through a pharmacist. So that's where the situation is with CBD and the classification by the TGA. We consider that state and national OHS laws and and guidance must be kept pace with, including the increase in prescriptions of medical cannabis to prevent future instances of unfair treatment by employers. Our submission also deals with the possibility of amending the disability discrimination laws to clarify a course of medication or treatment as a protected attribute. For the Mining and Energy Union, this is an emerging policy concern, and I look forward to assisting the committee with any questions emerging from our written submission.
Thank you, Adam. Tony or Stephanie?
Thank you. I also appreciate the opportunity to discuss medical drug testing within workplaces. The AMW looks after 60,000 members across the country, and our membership consists of tradespeople right through to lab technicians, through to lower skilled workers on a production line. So our members traditionally have heavy jobs, long shifts. In the newspaper sector, it goes 7 days, 24 hours a week. And quite often they're an older workforce. Our average member is 45 years or 55 years old, and we're a male-dominated industry. The impairment isn't something that's been around for a short amount of time. This has been something that workers have dealt with probably since the industrial age and probably prior to. However, we see in the last 2 decades, probably the last 10 to 15 years in particular, that companies have changed tacks and have used drug testing policies for a number of reasons, but I would argue to target older workers to get them out of the factory with little to no recourse or compensation. Some drug and alcohol policies require one strike, you're out, and we note that, rather than a drug and alcohol testing regime, it should be around impairment, because being fatigued is proven to be as dangerous, if not more, than 0.05. However, there's no testing regime for such things. It's also important to note that people have self-medicated for a long time, and you look at the rise of things like opioids and stimulants such as methamphetamine. If you're carrying a shoulder injury to get through a 12-hour shift, that's usually how people start the slippery slope to get through their shift. They take a little bit of a bit of a hit to get through. Then you look at the other. So you've got your mental health, your physical health, and then you've got your recreational usages as well. And we see this in professional sports where everybody is well aware that cannabis stays in the system as a traceable product for some amount of time, whereas methamphetamines, cocaine, MDMA, the list goes on, GBH, I can name a few, probably, I shouldn't say. 24, 30 hours out of your system, and people are well aware of that. So we're pushing people away from something that's been medically proven and has some sound medical research that deals with mental health, physical health, as well as recreational health, into something that's far, far harder. So we would like to see that changes, if any, are made are on a number of levels. Support offered to workers that have issues. Some understanding on how and when somebody is actually on a drug, but more importantly, some real strategies around impairment, around identifying of impairment, around options to deal with impairment. We had a member in WA, a company brought out drug testing. We had an understanding with that company that they would offer these things. And we got reports back that the company had sacked 2 of these workers. So we rang them up and said, well, you promised not to sack anybody, what the hell? And they said, well, when we had the meeting, the first guy turned up in his slippers and pyjamas, said, I've been smoking weed for 30 years, and if you think I'm going to give it up for my job, well, you're wrong. Now, initially I thought, wow, who would throw away their job for a bit of weed? But if you flip it, means he worked there safely without incident while smoking weed. He was a productive member of society while smoking cannabis, to sound a bit more sensible. And that's what you've actually got to look at here. The Canadian model looks at justifiable and demonstrable, impairment, and that's when there's testing. I was saying to my friends the other day, I started work in a factory when I was 18 years old. And I remember going out on a Friday night, all night, let's say drinking and having a good time. And I rocked up, my shift started at 6 a.m. in the morning, and I probably hadn't been asleep for very long and probably shouldn't have driven to work that day, I'm not going to lie. My colleagues pulled me aside and said, Piccolo, what are you doing? And I said, I had a great night last night. Well, you should have seen this person I was talking to, pretty cute. And they said, well, mate, come with me. They opened up the first aid room and put me to bed for a couple of hours. Now, when my boss came in and they were informed, he said, well, we've all been there, haven't we? And then on the Monday morning, pulled me into a meeting and said, Tony, that's not acceptable. Not only did you put yourself at risk, but luckily the guys pulled you up because you could have put somebody else at risk, right? And these are the types of interventions that workers, management need to be informed of, educated on, and the changes made, right? And I'll probably leave my opening statement there.
Thanks, Tony. Stephanie?
Thank you. So thank you very much for the privilege of appearing today on behalf of the Health and Community Services Union. We are the number 2 branch of the Health Services Union in Victoria and across the country, and we have the great privilege of representing the disability workforce, the drug and alcohol workforce, and the mental health workforce. I hope today some of our commentary provides a unique perspective, both in terms of how this issue affects our workers, but also how inaction in other workforces and across the community negatively impacts our members. So I think, look, the first thing I'd say is something our branch secretary, Paul Healy, says quite often is that any failure in social policy always becomes the problem of mental health. And certainly on this issue in terms of workplace drug testing, it doesn't discriminate. I think it's important to outline some of the non-negotiable facts that face my members at the moment when it comes to workplace drug testing. Look, on average, it takes Australians 20 years to seek assistance with addiction to drugs, alcohol or gambling, and they don't put their hand up because of fear, shame and stigma. When we consider something like the introduction of medicinal cannabis, which we emphatically support, something that we are acutely aware of from our perspective is that to get to a place where workers are comfortable and feel safe enough to collaborate with their union and with the manager to come up with reasonable adjustments, which has been demonstrated really fantastically in the Canadian model, we know that we have a lot of work to do, because the reality is compassionate, health-led responses to anything to do with drugs, alcohol or gambling are simply not present in the industrial relations landscape in Victoria. We know that this is really imperative, and we know that it's really urgent. At the moment, our current policy settings when it comes to drugs, alcohol and gambling are costing the country over $80 billion. The highest losses come from workplace productivity, so about 38%. And for us, we know that that's simply not good enough when it comes to working people who need an answer, but also when it comes to our mental health workforce who often are on the front line of having to pick up the pieces. I think too that something that's become more and more prevalent in our role at the Health and Community Services Union is that more union officials, more union leaders, and certainly more bosses are reaching out to our union to have confidential conversations about workers who, potentially might be grappling with risky substance misuse. On the whole, it's very difficult for us to provide answers that will ensure that those workers stay employed. I must say that every boss that has ever reached out to HACSU to have this conversation with us on the down low has been supportive of that worker and has wanted them to stay employed, but at the moment they're not able to have that conversation. Certainly for us too, we are very concerned that, in getting ready for this submission, we've done a lot of research and had a lot of conversations with drug and alcohol providers, with people who provide therapeutic rehabilitation, those who provide outreach, those who are on the front line in inpatient units. Certainly what's become abundantly clear to us is that there is a severe need for generalised alcohol, drugs and gambling awareness training across a plethora of sectors that needs to be standardised and that needs to be linked in with the Occupational Health and Safety Act and the relevant compliance codes that go with it, because unfortunately, as that's not mandated, what we find is that education levels vary across workforces. Tony mentioned it before, that we are starting to hear more and more now that working class people are opting to use harder substances in place of medicinal cannabis or black market cannabis because they are aware that it doesn't stay in their system for as long. For us, we find that very problematic. It's sort of like when you look at the entirety of the drug and alcohol system in Victoria, the way the policy settings are structured at the moment, we actually condemn working class people to become far more unwell before they're able to access the public system. And unfortunately, we're finding that working class people are going down the same route when it comes to medicinal cannabis and using other substances. I'd finish by saying that for us, we've got a Royal Commission sitting there. We've got Recommendation 16 called Establishing Mentally Healthy Workplaces. We detail a lot of the interventions we would like to see in our submission, particularly the introduction of recovery-ready workplaces, regulated workplace drug and alcohol testing, and most importantly, a health-led response to drugs, alcohol and gambling in the workplace. Because as I said, unless that's embedded as a cornerstone of industrial relations in Victoria, we won't be able to get to the place where people are confident and comfortable in putting their hand up, collaborating with their unions and employers to come up with reasonable adjustments when they are using medicinal cannabis.
Thank you. Thank you, Stephanie. Thank you. Oh, yes, Mark.
If I may, I've not heard anything from my blue-collar colleagues, I guess, that I would disagree with. What I would say is, just so it's not missed, our industry is a potentially dangerous industry. We believe in impairment, but unfortunately that hasn't been something that's been looked at too hardly. There are some systems where they can use a screen-based system and the computer allocates exactly the responses over many times, so they can utilise that. But I would say we're very safety conscious to the point that we put our drug and alcohol testing policies into our enterprise bargaining agreements at Hazelwood, for example, at Loyang Power Station, and that's to ensure that every worker understood what's expected of them and what the process is to make sure that when and if something comes up, it's addressed. We have found that, as the health group was saying down there, that quite often we'll be approached by companies that don't want to highlight something publicly and say, how do we keep this employee? What can we do? And so unfortunately we have to come up with solutions that might be time off without pay because there's no proper process to help that process be encouraged so both parties get back to work, shall we say. So I'd probably just leave it at that.
Thank you. Thank you very much for actually giving an insight lesson to different perspective, lesson different industry. I'll start lesson to, let's see if I could just mention, just quickly ask Adam. You mentioned prescribed medicinal cannabis has to be part of it. Does that include self-medicated as well?
Our submission doesn't go into self-medicated.
Just
We
prescribed,
only deal
okay.
with medically prescribed cannabis for good reason. And
Yes.
as we've highlighted in the opening statement and in our submission, we say that there should be policy settings and procedures in the workplace that deal with that on the same level as I mentioned, other medically prescribed medicines that are used to treat different conditions for different people. And things like opioids and benzodiazepines are not only, can cause impairment, and they all come with warnings. You can get simple medication that comes with, like Phenergan, for example, which is an antihistamine, causes drowsiness. And I know because I'm allergic to bees, so I have it, and I've had it before for getting an injection, and it knocks you out, right? Yeah. So that's just a pharmacy. You can get that over the counter. But there should be a policy setting or procedure that deals with medically prescribed cannabis in the same way that other prescribed medicines are.
Yep, thank you. No, definitely more clear. Now, I'll go over to Tony. We've already under occupational health and safety. Now, there's a commerce on the employer to provide a healthier workplace and a safe workplace. At the moment, is there any formula or any formal screening to prevent incidents from happening if the person is some sort of under any influence?
Well, I guess that relates back to my point I was trying to make earlier. Because policy and government has been devoid in this area in reality, other than saying they must provide a safe workplace, companies and unions have come up with their own means and ways, and some workplaces don't have the same strength or power in a power differential to work that out. And some are merely ticking a box. Others are saying, well, if you prang the forklift or hurt someone or hurt yourself, then we test you as a way to mitigate our exposure to a work cover claim. But without on-site training for workers who stand side by side with their workmate every day or workmates, then are we really interested in protecting people's health and safety, or are we merely, doing it out of etiquette and to mitigate exposure to a common law claim, right? Let's be honest about that. And the example I gave you earlier about myself personally, where I came in under the weather and my workmates pulled me up because they know me and they say, not great today. I think it's important to talk about medical cannabis as well in relation to self-medication. You asked the question of my colleague here, and I want to add further insight. Remembering medical prescribed cannabis has been around, 2016, 2015? There's plenty of people having to find their own ways to medicate themselves prior to. And going to a doctor, getting a prescription can be quite embarrassing. And if you've already, for the last 10 or 15 years, found your own means and ways, and it's pretty easy and it might become your friend, or it doesn't matter why you continue to choose that way. But at the end of the day, it's the same substance, right? One comes in a packet and one comes in a bottle. But it's the same result. And at the end of the day, whether it's fatigue, whether it's... I lost a child this year, or last year, sorry, and there were days I probably shouldn't have come to work, and my workmate said, go home. So impairment can come in all shapes, sizes, forms, and in reality has the same effect. I remember driving to places and not remember getting in the car. Now that's as bad as having too much Phenergan, right? Or as bad as, it's a thing, right?
Yeah, agreed.
But on top of that, I want to go a little bit further. And because drug and alcohol policies, for the most part, have been allowed to be, unions have their say and do the best they can. But if members don't back in their union advice, and some members have more experience in doing that than others. Some drug and alcohol policies require you to tell them what drug, any drug you are on, prescribed by a doctor. Now ask yourself why that might be. Yes, there might be. Your doctor tells you if you can't drive a heavy vehicle. Your doctor tells you if you shouldn't drive. But what's it really about then? It's really about when you go to make your work cover claim, they can say, no. They've had a bad shoulder for 10 years. They've been on, they've been on aspirin, and because they want to go to that level, And think about that for a second.
Actually, I'll open up the floor.
Thanks, Chair. Thanks, everyone, for coming in. We had evidence this morning from what I'll loosely describe as the drug testing industry, representatives of people who conduct drug tests in their peak bodies. Obviously, they were here telling us how wonderful their services are, but it was clear that they can detect presence but not impairment, and they don't go to those issues. But clearly, more and more workplaces are turning to them. I'm wondering if you had evidence you'd like to give to the committee about your views about how and where we should be dealing with employer-initiated requirements for drug testing, and whether things like mandatory drug testing requirements are appropriate, and where and how we should be dealing with those things. Mark, did you
So
want
I've had the unfortunate opportunities that I've been dealing with the drug testing labs for probably, I don't want to say 4 years, but somewhere around that period. Probably interacted with probably 10 years ago. My partner, she is an authorised drug tester back from, she's not doing it anymore for, I think, Program Skilled, for example, covering all of Eastern Victoria in the past before she changed jobs. Now, so I've got a fairly close understanding, and there came an opportunity a little while back when we were updating one of our drug testing documents about the level they were testing for. Now, my understanding from memory, it's going back a couple of years now, is that the testing machines, the old testing machines, tested to a certain level. I can't remember the figure, let's say 50 or 100 or whatever it might have been, 25. And the new ones are so sensitive, they test down to, say, a quarter of that, might be 5 or 10. I really can't remember the numbers, unfortunately. And what that showed is that they were picking up stuff from a week before or even months before, depending on the use. That was THC, for example. So the problem we had is that all the companies are saying, oh, well, we're now going to drop the standard to this new level. So someone could go overseas on a holiday, come back 3 weeks later and then lose their job potentially. And it turned out that it's because all the new Australian standards dropped, and there was no interaction with anyone, just the Australian standards. So there was no one knew about it till they said, these are only machines we're going to make. We managed to deal with one site and said, you better buy a couple of the old machines while they're still available, because it was the middle of an EBA, and that's how we have our drug policies. So that is an issue. What I've just come across recently, and it's going to sound, the name's a little bit confusing, it's fingerprint drug testing. Now what it is, it looks like a COVID sample. You put your finger on it, you put each fingerprint across it, so you don't catch a fingerprint, they just call it that. And you get a result, and that result is based on impairment. It's a model they use in the UK. It takes away the need for urine tests. It tests pretty much all the drugs you're looking for, and it's they're going through the process now of Australian standards, getting it certified, which is a very long process. So I'd probably say we support that sort of stuff, because it does talk about impairment that's been used in the UK for probably a decade or more. So that's all I'd add for that. It's very complicated because Australian standards seem to be setting the target, which has no no connection with impairment, which is the key point we're trying to save here.
So our strong belief, and this might be controversial to say, but we say this after really examining the evidence of what's occurred in New South Wales, whereby those construction unions up there have clauses in their agreements that say that no workplace drug testing of any kind can occur unless the employer has paid for general awareness training. Within that EBA, they state which general awareness training has to be undertaken, and I suppose for us, we are strong supporters of that, because without regulation in terms of education of workforces, and I hate to say it, but our view, it should include the public sector, which means the government would be up for that training if that were to roll out across public sector workforces. But it should happen anyway, let's be honest. Is that without regulation, there is no guarantee that the training that's occurring across workplaces is fit for purpose. It's our strong view that that training should be developed in partnership with public sector providers of drug and alcohol training. So I'm thinking particularly Odyssey House, Windana. The reality is the public sector providers of drug and alcohol treatment in this state are fantastic, but also in partnership with lived and living experience providers like ADA, for example, who all came from the shop floor, all had lived experience, and are all an incredible example of people who have gone back to work. So for us, the regulation shouldn't just be applied to the actual testing regimens themselves. It should also, a lot of work should be done before that to ensure that education is rolling out across workforces. And we'd also include, being really upfront and being really frank about what impairment could occur with medicinal cannabis as well. Going low, going slow.
If I could answer that. Look, Canada legalised cannabis in 1999, and across many arbitration and courts have come to an understanding that when there's demonstrable justification on reasonable grounds or probable grounds. The other three, that people in seriously dangerous industries, they weren't even automatically justifiably tested. There was only 3 considerations for that too, and that is there's reasonable cause to believe that an employee was impaired while on duty, following a workplace incident, accident or near miss whose cause was not attributed to mechanical or other non-human failure and where there was a potential for significant harm, or upon returning to work after treatment for substance abuse. But picking up on Steph's point and on Mark's point, it's really easy to offload someone if they've got a problem. It's really hard to not give somebody an option or an answer to get fixed if they have a problem. It's really to catch, to surprise a jumped out of the bushes and I've caught you today approach, rather than a systematic, educational-based, evidence-based approach is a really haphazard way to do it. And then to only do it after a serious incident or accident or near miss prescribes people to get either lucky that they didn't get seriously hurt or significantly hurt before we catch somebody. But I'm promising you that if somebody's under the influence, usually it's not just on one day. And having people trained in identifying telltale signs or cries for help is one thing that's really important. But there's no point asking for help if you've got nowhere to send people. And so if I say to you, I've got a problem, I go, well, mate, you've either got to go off on unpaid leave, drain your super, go get some private rehab, or just try and do your best, and I won't tell the boss because we don't want you to lose your job. And you can't fix one without fixing the other, really.
If I get time, I'm going to come back to the rehab question later.
Yeah, no. David?
Oh, thank you, Chair. Thank you all for your very, very thoughtful contributions. It's been fantastic. We had 2 really interesting poles apart type positions put to us today. One was from WorkSafe, where they drew the committee's attention to the fact that there was no express requirements, mandate or prohibition around workplace drug and alcohol testing policies. And when asked, well, is that your job? They said no. And so that when they were asked, is it somebody else's job? They said, well, it's not for us to say it's somebody else's job, which is not very bureaucratic, but anyway. And then on the other hand, as Mr. Batchelor referred to, we had the drug and alcohol industry merchants here who were basically saying it should be mandatory in every workplace.
Test early, test
Mandatory.
often was there.
Yeah, that's right, that sort of thing. I guess I'd be very interested in your thoughts as to if there was to be a more contemporary legislative or regulatory regime, what might that look like, and where would it be located in terms of legislation and such like, if that's possible?
I might just go to pre-legislation. For those that aren't aware, generally, as was mentioned, there is no requirement to have drug and alcohol testing on sites from a employee type perspective, what we've done is we've been proactive as a union to say to all of our OH&S reps, which are usually our union members, and we go, you don't want to work with a colleague that might potentially put you at risk. We need a policy in place, and we'd have definitely high standards of what we want, which would be, as mentioned by Tony, some process where they get a second, third chance and some process to help heal that. You would talk about the testing levels, and we can never get to impairment because we couldn't get the testing parts, and made sure that we had an opportunity for employees to, I wouldn't say dob in a mate, because that's not what it's about some sort of intervention. And then we put that to the OH&S committees, and that's how we get them. Because quite often when the company would propose something that's pretty draconian, and all the OHS people would just shut it down and not have it. So I do think it needs some boundaries, and I think if you look at some of the unions that have put it forward, like ours and others, you'd probably find that would give you a bit of an idea of framework. I'm sure Tony's probably got more to add to that, or even Adam.
So just to clarify, you're saying WorkSafe has said it's not their role to have a drug test or drug testing policy, and where would that sit in the legislation?
So the only document they've produced is the Guide for Developing a Workplace AOD Policy, which was produced in 2017 and hasn't been amended since then. So it actually, in Victoria, it virtually came in the same time as medicinal cannabis was legalised.
Yeah. I mean, I don't think I can necessarily answer that question because it's been an age-old policy, the position where the legislation that's in our submission talks about the duty to eliminate risks to health and safety, and then what flows from that is workplaces individually develop it. But it might be the case that that guide, which WorkSafe used to supplement legislation and even codes of practices, probably needs an update. That would be my suggestion, and it should be brought up to sort of the modern standards, so to speak, because of the things that we're talking about. That would be my suggestion.
So I would say we find that response extremely disappointing. We go in great detail in our submission about the very clear and key role that we believe WorkSafe and the Occupational Health and Safety Act as a piece of industrial might can assist in this endeavour. I do, in terms of the WorkSafe guidance note, I want to get this word for word. When we put this submission together, we note that the foreword of the WorkSafe guidance note states, employees unfit for work as a result of alcohol and other drug use put themselves and other people in the workplace at risk of harm, and co-workers may feel obliged to cover unsafe work practices or not report an affected employee due to loyalty or fear of circumstances. Certainly, given that we now have the Royal Commission into Victoria's mental health system sitting there telling us we must establish mentally healthy workplaces, we find that sort of rhetoric deeply problematic, very unhelpful. What we would like to see is the introduction of alcohol, drug and gambling health and safety representative refresher training to get people on the job who are confident and comfortable having those conversations, because as Tony alluded to, it's one thing to put your hand up, which is extremely courageous, and say you have a problem or to disclose that you're using medicinal cannabis, but it's a whole other thing when you are the worker being disclosed to. You need to be confident and comfortable to know what to do, what to say, and what the industrial framework is. Yeah.
It's not 3 minutes.
Do I keep going, or I'm always after the buzz? Is that an issue? I don't know. It's not Who Wants to Be a Millionaire, is it? Did I miss out on a prize? Look, in relation to that question, I would say there definitely needs to sit somewhere in legislation, but it also needs to see a formation of, you've got health and safety reps, you almost need an impairment, whether the impairment is taught to the health and safety rep, whether it's taught across factories, a requirement across that. But there also needs to be the imperative that a company must support somebody through this. I mean, where's the community in terms of getting around a worker? Like, this is a community issue. It's not as I said, not many people will choose impairment over their employment unless they actually have to, right? Not every time you smoke a joint at 6 p.m. after doing your job, are you impaired at 8 a.m. the next day? And that's the true travesty of this. And there's not many companies, even if they wanted to, that have got options to get help, right? So they're forced with either stigmatising you, turning a blind eye, or sacking you. And unfortunately, the first two happen for a while until they sack you without any legislative guidelines, without any legislative framework. Gives companies the audacity to ask you to disclose if you are on Panadine Forte, if you have taken Nurofen, if you have taken medication for gout. And some policies go as far as to say if you get tested and haven't disclosed that you're on a drug which is legal, which is not of impairment in nature, that they can terminate your employment. And so what is this actually about? Is it a fishing expedition to find reasons not to help you should you get injured? Or is it about mitigating a company's exposure to a common law claim? I would argue that's what it is actually about, than providing a workplace that is safe and so on. Thank you.
Thanks for that. Sam?
Thank you, and thanks so much for appearing today. I'm interested to hear, Tony and Stephanie both referenced the Canadian approach to these issues, and I'd be curious to hear a bit more about what they do differently there that we could learn from.
You go.
Okay. First of all, they have that clear sort of trigger point, which is a justifiable and demonstrable reason for testing, because you're obviously impaired or you're obviously not on your game, and then in sort of more dangerous occupations, that it's either that first reason, justifiable and demonstrable, or it's after a serious near miss or injury within the workplace, or you have returned back after being receiving treatment for such issues.
Mm-hmm. So it's not sort of random or mandatory blanket testing. It's actually in response to a particular trigger that the testing is done.
Yeah, so you might smell alcohol in somebody, or you might in one of our case studies, somebody got terminated for suspected drug use who was a diabetic, and we got their job back because we proved that they actually weren't on drugs, but they were needing their treatment, and so as a result, was slurring their words and stumbling about and came across drunk, but they actually weren't drunk. So, but that's an impairment thing. Where if somebody had said, "Hey mate, where's your insulin?" and that sort of gets back to that point.
Excuse me. I think for us, and I mean, it's sort of strange to talk about these cases because it feels as if Victoria and indeed Australia is, years behind in terms of how we deal with drugs, alcohol and gambling philosophically, comparatively to places in Europe, America, Canada. But there was a key case, Bird v Lafarge, Canada, where the worker did end up, it was an unfair dismissal, essentially, and the worker was found to be in breach, but they weren't in breach because they were using medicinal cannabis. They were in breach because they didn't bother to tell their employer. And employers over there have in place industrial mechanisms where you can disclose, the unions support you disclosing, and employers now have an imperative in Canada to provide reasonable adjustments. So this worker wasn't sacked for using medicinal cannabis. It was because they didn't follow the industrial process already put in place to protect that worker. So I think in a dream world, that's exactly where we want to be, where workers, if they are to get stood down or in trouble, it's not it's not for the use of medicine, and it's not for accessing critical health care. It's for not following protocol. And hopefully we as unions, we're going to be in a position where we can catch workers before that happens. And we know it's really important too, because in our research, we were really grateful to have a lot of conversations with our industrial comrades over in the United States and in Canada, and something that became abundantly clear to us, and something they all said over and over and over again, was that if they could do cannabis, whether it was Medcan or legalising recreational cannabis differently, the thing they would have done first was get the industrial frameworks right and get the laws right, because unfortunately a lot of those states in the US and Canada find themselves in a place where cannabis has gotten way, way, way ahead of them, and workplaces are still, decades behind, and employers sort of don't know what to do. So this legislation, while it's fascinating to watch over here to see law catching up, I can also understand that for employers and their industrial representatives, it's really tricky and really complicated. But ideally, that's where we want to get to. But we are concerned that because of where we sit philosophically, we might be ways off that yet.
But just one other comment, and just dealing with medically prescribed cannabis, is that it should be treated the same as other prescription drugs and dealing with impairment, but there needs to be a balance between the therapeutic benefit to the employee and also risk in the workplace, and that's why and you don't hear or see that in any procedures. There's no mention of there's that balance. So I think that's an important aspect.
Just a quick response to Dr. Mansfield's question. In regards to the random sampling, what I'd suggest is we had, one of our original EBAs had random sampling. What the company would do is they'd target the group that had the highest level of physical work to do, they used to do their shoulders, and they'd keep targeting that group for testing and eventually get rid of people. So what we did is we basically made sure that they could do that a certain group 2 or 3 times, and after that had to test the entire workforce, including management, which they weren't real keen on, but we put that in the document. That then cleared up. It became a small issue because they thought the cost was going to be expansive. So what we did is we reduced the randomness. In other words, you sampled more people, but only tested 1 in 6. So everyone was getting that opportunity where they dragged down to, oh my God, I could be caught, so they'll start to be refreshed that it's an issue. At that point too, once management gets involved, it's them sharing the same responsibilities as a worker. So just a bit of feedback for you.
We did that. We did do that, but as an industrial campaign to stop the testing because the company realised how expensive it was going to be, and so nobody got tested. So both work.
Richard?
Yeah, thanks, Chairman. Thank you, gents and Stephanie, for coming in today. And it's really interesting and refreshing to hear this perspective as well. But I had a question for you, Stephanie. You mentioned just right at the top that New South Wales,
Yes.
there you have some EBS there where there's no testing without training.
Yes.
So I'll try and frame it a little bit that if you're taking a prescribed medicine or you're indulging in recreational drug use that has it's generally understood that it has the risk of impairment. What the training itself, what purpose is the training doing that isn't already sort of a common understanding that don't work when you're impaired?
Yeah, absolutely. So I think in the first instance there is a grave lack of education amongst workers about the negative impacts that drugs, alcohol and gambling can have. But there's also a grave misunderstanding that every single person who engages in drugs, alcohol and gambling is a junkie or don't care about their family or their employment. There are, many people who self-medicate for a range of reasons. And as part of that general awareness training that we're really interested in is making that critical connection between mental ill health and potentially risky substance misuse, with the acknowledgement that not everyone who uses illicit or an illicit substance is using it to self-medicate. So I think that's of critical importance. What we also want to stop too is instances of workers who might say to their colleagues, if you use ice, it's out of your system quicker. Like if you don't like alcohol, just use ice on the down low. That sort of thing we definitely want to stop. But certainly too, while there's an educational aspect of it as well, there's also a part of it that we're really hopeful normalises these conversations. I said at the top, it takes an Australian 20 years to seek assistance with addiction. 20 years. 1 in 5 Australians will grapple with a risky substance misuse in their lifetime. What that is actually translating to is more and more impacts on the mental health workforce, because when you're in a state where the public drug and alcohol system, while great, we've got over 500 rehabilitation beds, it's simply not enough. While we've got WorkSafe, where, and the OH&S Act that doesn't adequately deal with these issues, you've got all of these compounding factors happening. What we know is that more and more workers, who perhaps if they were confident and comfortable and were safe and protected in putting their hand up earlier, if they'd had general awareness training, if it was normalised on their work sites, maybe they wouldn't be ending up at the inpatient unit at the Alfred, and by that point lost their job, lost their house, So you can see how it's a snowball effect, and we know that when it comes to risky substance misuse, the biggest indicator is trauma. And you can't be what you can't see. So if we don't start normalising these conversations on work sites, logic prevails that workers, they simply won't talk about it.
Thanks, Stephanie.
If I could answer that, if people knew what people knew, there wouldn't be any TAC ads, Education is an ongoing battle and an ongoing journey, and people migrate through parts of their life. But I think we are remiss if we think that impairment merely comes from drugs and alcohol. Impairment can be from fatigue, can be from stress, can be from a mental health disorder, can be from, even financial concerns where you're, presenteeism is a thing, right? And if we think that by sticking somebody's tongue on a piece of plastic once every 6 weeks is, hell, I don't care if it's every day. There are many other factors of impairment, and if we're not looking at that, then what are we actually looking to achieve here? Are we looking to provide a safe workplace for people, or are we looking to kick those that don't conform into our agreed set of values? I mean, alcohol kills more people in this country than any other drug combined. It is the most dangerous drug, yet it's legal. So therefore, nobody bats an eyelid when I say I got shit-faced last night. It was a Friday, so I didn't have to work, sat down, and I didn't drive my car, so that's okay. Right? And I think that's what the point that we're sort of missing here. Impairment comes in many shapes, many sizes, for many reasons, and can be brought on for many different triggers, right? And I think that's where the training and the observance of people that you work with every day, you spend more time at work, I spend more time at work than I do with my loved ones. So they're probably going to pick it up way before my, significant other, or my mate that I see, luckily to see once a month, what I mean? And that's the point. That's where education comes in, and that's where I'd like to see a change.
And everything you said, I agree. In essence, it's particularly early intervention in all these things. But I would think that's a public health issue. So with the training itself, what's the union's position of who should pay for that training? Because as a public health issue, as opposed to an employer issue.
Yeah, you go.
Who pays for the drug test? Who pays for the drug test? Who?
Presumably the employer.
That's right.
Yeah.
So, I don't care who pays for it. I think that's, a secondary thought. But obviously we're a union, and if you're happy to pay for a drug test to punish people, you should be happy to pay for an educational process which keeps your workers safe, which keeps your business more productive. As I said, presenteeism is a thing, right? There's cost to the Victorian economy of, billions of dollars where people turn up and stare at a wall all day, or run their machine at half mast because they've got, I'm sure we've all been there before. Anyway.
So I guess in response to that, I'd point to our first comment where we said that any failure in social policy becomes the problem of mental health. And I suppose from our perspective, we would say, yes, there is definitely a role to play for public health, but there is also a role to play for WorkSafe, the occupational health and safety regimens, and all of business. I mean, I don't think we can continue to make this solely a public health issue whereby all of the responsibility falls to public health. I don't think that's reasonable, and I don't think it's right and fair in this economy to do so. So certainly I think it would be very dependent on what sector you were talking about. I mean, if we look at the examples in New South Wales, whereby the construction unions up there have the clauses in the agreement that say no workplace drug testing can occur without training. Most of their agreements are with the likes of Mirvac or Lendlease or big sort of giants that are relevant to their sector. So my inclination would be to say the employers relevant to the particular sector that you were dealing with.
I think just from what Tony said and what was just said then too, is that if there's this incumbent onus on employees to follow policies and not breach policies, and that's the standard of the employer, then in terms of cost and dealing with that, there should be an onus on the employer to provide proper training and education, but that's also underpinned by supported training programs, not just some program that they design themselves so they can tick off on a box and go, oh great, we've met our liability risk problems.
But if you're sort of, just to make sure you feel like you've had a proper grilling here.
Is this a grilling? This is soft. Bring this on.
Otherwise it's just an echo chamber, right? So, employers might say, at what point do we sort of have to take on the public health role when we're just trying to make sure we're running a business and we're taking on the public health? And good, if you've got an answer, that's good.
Mr. Welsh, what I would say is that the companies I deal with, the large ones like the AGLs, Energy Australia, and many others connected to that, including the subcontractors, is they have a lot of training courses. They have a lot of boxes they have to tick for operation of plant, regular updates. Yeah. One extra course, to be honest, is pretty minor, and they usually have these things that can be done in a pretty short term. It's not like we're talking a day's course. We're talking sometimes 30 minutes, or not even that.
But is that materially different to box ticking?
No, what I'm saying is that, but it needs to be integrated at a legislative level, and then the companies always want to add something themselves anyway. So what I'm getting at is they're going to run a course. If you've got legislative boxes they need to tick, well, that's what's going to be ticked, and they'll add a few extras in there for related stuff. So I don't think it's an issue. But I would go to the point that we mentioned, things such as fatigue. I can tell you, I've pushed fatigue for many years, and I can assure you that quite often we come across rosters that hit the fatigue limits, and there's processes they kick in place where they individually, the management will come and assess the individual with a face-to-face.
Yeah, and I totally agree with that, and you are spot on that there are all sorts of impairments. There is a risk, though, that you start conflating voluntary impairment, if you like, versus involuntary impairment. So I think there should be some distinction between the two, that we don't put all the worst case scenarios of involuntary impairment with the other kinds of cases where people are recreationally doing that.
I'd suggest the training costs are very minimal, to be honest.
Do you remember, Mr. Welsh, there was a saying when I was much younger that, if you drink and drive and you make it home, you're a bloody legend. Remember that?
Oh, yeah.
Right. People would... You tell somebody you drunk drove and drove home, not many people at a barbecue go, well done, mate, would they? No. They wouldn't, right? They just say you're a bloody idiot. And that's probably where that whole program come from. So to tackle a problem has to have many facets. Now, I guess the real question here is, what's the ends of the means? Is the ends of the means to limit my exposure and to kick workers out, or is it about providing a safe workplace? And I guess if you look at the issue from different lenses, we'll give you a different answer. If it's truly about providing a safe workplace, which, let's face it, if I'm a ma and pa employer and I've got 6 or 7 people working with me, one of them's whizzing by on a forklift, well, then it's inherent that I want to keep not only my workers safe, but myself and my partner safe, right?
No question.
No question.
Yeah, no question.
Or whether you're an Amcor and you've got 3,000 employees, you'd hope you've got the similar thing, because you might be one walking past that gets run over by a forklift too. Or that sort of provides the space of, whether in the current legislative framework, if you've got a health and safety rep, which every Australian business can have one, has a requirement to get training off the job that the boss must pay for, and a refresher course every year, not every day. And, because a smaller employer really doesn't have usually a HR department, it's usually one of the partners' job to do that stuff, that you might find that they would actually prefer to sign up to a registered course, a one-day course, or whatever length it went, versus it's usually the large employers that say, well, I could save a couple bucks and do the tick box. You're more likely to get a tick box from a large employer than a ma and pa, because they don't have the time nor the want to design this course, right? But then for this side of the room, then you've also got to have an answer if you've done all the impairment stuff, and I don't know if I'd call it voluntary versus involuntary.
Well, for want of a better term.
I get you. Discretionary, maybe. No. Uneducated. But if there is someone with a genuine problem that's been identified, then the next step of that equation, or the next face of the dice, needs to be, because it happens to union officials all the time, where workers, bosses ring us up and say, got this person, they're in trouble, I'm worried if I sack them, they're going to kill themselves, or they're a great person, they've worked here for 30 years, I don't know what to do. And then neither do we, so bosses don't know what to do, we don't know what to do, and we had an option to send someone to a rehab and couldn't get them detox for 6 weeks. So you can't have one answer and not have another answer. You can't have, you get what I'm saying. So the problem in itself is pretty complex. But I think we need to refer back to impairment is the first hurdle.
Correct.
And then identifying strategies around that, and having people that are equipped to recognise when somebody's impaired for whatever reason. And able to have a conversation, because sometimes it's just a conversation. You know what I mean? My mum died last night, haven't slept. Well, go home, mate. Have the rest of the day off, yeah?
Just to add to the cost conversation, a lot of our guys, they've had, the company spent, some of them will tell us they spend $500,000 on their employees. I think it's probably close to the $150K to train them up, and obviously some of them are 5 to 10 years till they get into the positions where they're running the place. So you could theoretically say it's in the hundreds of thousands of dollars for training to get them there from their skills perspective. I don't think a small cost in terms of making sure they can keep them there is an issue, to be honest.
Thank you. Rachel?
Thank you, Chair, and thank you to everyone for appearing today. I want to get into, so it seems as though random drug testing or drug testing in the workplace is becoming more common. Would you agree with that?
I think the push was some years ago. It's become standard for most of us unions to push it, so I wouldn't say there's a change. I think the difference is they're going away from what most people would perceive as impairment to just to tick a box for testing from the standardised testers.
But from the industries that we represent, that's been part policy for quite a long time now.
We'll get into more detail with that.
In terms of my industries, or the industries that my union looks after, I don't own any industry, not yet. It sort of was probably 10 years ago a really strong fad, and it comes in sort of waves of the new fad to bring it back in, or where they haven't got it over the line, and we've got a union one to re-push it back through. So.
Okay, and I guess I'm just picking up on a few things that you've mentioned, which is, someone whispering in the ear of, meth sort of is out of your system within 24, 48 hours compared to, other medications. Do you think that there's, other drugs, do you think that there's some unintended consequences of having such firm policy positions of your drug testing is going to pick up X, Y, Z, and that those drugs we know are out of your system within 24 hours. So someone might be more inclined on a weekend to party with harder drugs comparative to potentially using, cannabis recreationally or even just accessing a medicinal cannabis prescription. Would you say that that's anecdotally something that you're hearing?
I could give one example, and that is that some years ago, it was some years ago now, there was a person that took what was legal at the time, I think it was synthetic marijuana, and they tested clear. But people sort of working with them knew there was a problem and reported it,
Yeah.
but that's why the test was kicked off, come back clear. And that would be a case potentially along the lines of your questioning, that because there's something they can take that's harder than maybe some alcohol or something the weekend before or the week prior to work, weekend starting prior to working Monday, I think that is a risk.
I'm a union and I'm not supporting employers, but I think there's a word that's been used a lot, which is impairment, and that should be the reason for testing. And I don't pretend to be an expert, but all the expert reports that I've read, and there's reports that have been filed in this matter, is then there does need to be some sort of science behind what thresholds are, how you do that. So I think there is going to be a nature of a prescriptive nature to it. And the reason for that is in some ways is because the employer then says, well, look, this is the standard. Everyone at least knows what the standard is.
Yep.
Now, probably the unions don't agree on what the standard might be. And also, too, there's the impairment and also the other policy positions about that. And I don't have the exact answer, but I think that's what underlies it, is that then that there is, an apparent science to most of this, of it. And that's why you have that. But I'm not saying, I'm just talking again to
I can assure you, when this new testing model came out for the THC, we had employers contacting saying, how do we deal with this? We're not interested in the lower level, but that's all we can buy for the replacement machine. So even they know it's not realistic, but it's the only standard they've got because the Australian standards changed without any consultation.
Yeah.
But I think it's also important, and this comes back to impairment, to recognise that impairment is different to usage. So if I had a puff of a joint of weed nowadays, you give me one puff of a joint and I'm pretty cooked. You rewind when I was 20 odd and give me 10 Hong Kongs and I was flying, I was having a great day, right? So you know what I'm saying, right? So there's impairment and there's usage, and it's just like an alcoholic. I remember there was a report about somebody driving a car and they blew point it was like 6 times the legal limit, right? And somebody said, because it was a woman, said most men would have been dead, but because this person had built up a tolerance. So I'm not so this is where the impairment model around, the eye coordination, the hand type test, because this is what makes it really complicated. I think getting back to the synthetic stuff, there was a report on Canberra, the pill testing thing, had a product that was 20 times stronger than fentanyl.
Just on that, it's right. There should be impairment and understanding what that is, and also then you have the more scientific, drug testing, etc. But I mean, there's an expert report, I think, he's quite is specialist in particular fields, Professor McGregor,
Yes.
and others, and there's toxicologists that say, just so we understand what we're saying, is that if you go over drug threshold, that's not necessarily meaning that you're impaired. What it is, that's indicative of recent use, which then you look at what is the impairment. So that's...
And so like a random drug testing would be sort of more of a gotcha moment rather than, this person looks like they are a bit wobbly, they're not making eye contact, and I'm assuming that's sort of where you're referring to that Canadian model of this person appears to be impaired, and then I'll test for the drug.
And if you think about that, right, you think about that within a workplace, isn't that, the community I was talking about, where I say, hey, you don't look right, are you okay, is the first part of the conversation, rather than, hey, can you come with me to a room, I want you to blow in this bag and let me swipe your tongue. Like, isn't that the kind of workplace and methodology that we want to see generally in the community?
Well, I'd note too, in New South Wales, if someone was to fail a drug test and it came back positive, that worker is stood down on pay, true. But in the first instance, the health and safety representative is called, an alcohol and other drugs worker is called, and the organiser is called simply for a conversation, just a conversation. It is very rare that people in New South Wales get the sack if they do come up positive on a drug test in New South Wales, because they've embedded a compassionate, health-led response within that sector. And we would say that certainly at the moment, if you look at the jobs and skills plan, we need 53,000 more healthcare workers in this state in the next 3 years, 27,000 more manufacturers, 16,000 more construction workers. This is not the time to be kicking working class people to the curb and condemning them to losing their job. And as Tony pointed to before, many, many times, withdrawing their superannuation out on compassionate grounds to go to private rehabilitations that for the most part are not regulated.
Well, thank you. Lee, would you like any questions, Lee? Or Dr. Heath? Dr.
Yeah, I'm
All yours.
here. Just a couple of questions. So first of all, thank you for your presentation. So maybe drug testing may not be as effective as other sorts of training, for instance, spotting the signs of impairment. Is that what you, would you agree with that statement?
I would say we need both. And
Right, so, but it would be sort of a stepped approach. So first would be some sort of impairment test or training to spot the signs. And then the second thing would be a follow-up drug test.
Well, I would suggest that in general, when someone is either reported or if there is a random test, that would then require usually the tester themselves, without the company's knowledge, to discuss their medication, their prescriptions, and they would make an assessment whether that level was there. And in that conversation, there is a little bit of leeway for that tester to make the opinion whether they're, whether they've got impairment. And that will sometimes, from what I'm hearing, will make the decision tip one way or the other, whether they report to the company that it's a negative or similar or a positive. So it's not necessarily the measurement, it's the interaction they have with that person and a list of their stuff. So either way, they're connected. I wouldn't pick one over the other personally.
Yeah, right. So if we were to give a recommendation, because this committee will provide recommendations to the government.
I'd probably refer to the expert opinions of the reports, I would probably suggest.
I would say that workplace leaders and workers in general, as well as employers, to be fair, an educational program is rolled out on what impairment is, some of the triggers of impairment, and it's not just drugs and alcohol. There's a whole myriad of impairment, and that all impairment is just as dangerous to a degree as any other impairment. The levels that of impairment, a measurement of that level of impairment, and depending on the response of, like if you go to a worker and you say you're stumbling around, you look a bit under the weather, and they go, "No, I'm fine," well, then a drug test would be in order because it's demonstrable and it's justifiable, right? Like it's called for it. And so the first step is an educational program for workers, employers, and then an impairment developed test of whatever that nature is. And then the third point is a set of tools that can be given to employers and workers on how they can refer different impairment and different, they might need to go to the GP and get a mental health plan, right?
And you think that all that should come under be the responsibility of the employer?
So providing a safe workplace isn't it? And if you're impaired because you're suffering from grief or trauma, then fatigue, it's your responsibility to identify that. If somebody, I'll say this to you, if somebody turns up because they're fatigued or from trauma, or grief, and you go, well, I haven't got any other answer other than to blow into this bag and lick into this this stick, and they come back negative on all because they haven't had drugs, are they any safer than they were 15 minutes ago? Is there an inherent risk to people's health and safety, including potentially your own? And so therefore, we need to be trained in identifying and having a suitable response for any form of impairment that's presented, right? Because, and let's be honest here, employers have, for the most part, since the industrialisation of the system, right? Because, yeah.
I don't understand the terms of reference here is around what I perceive as prescription medication. But I would say one of the big ones we run into with fatigue, for example, is when a company would have a very large project that they're trying to squeeze in such a short period of time. I can think of just months ago where the company had someone working, let's say, 12-hour days for 18 days straight without a day off. And they were longer than 12-hour days, I can assure you. So,
that was actually one thing I was going to ask, because somebody said, that a lot of people will take drugs to get through a shift because they need a hit. Like, I would say then don't change the drug policy, change the work practices, because that's just wrong, I think.
Well, I know the individuals in this case, and I'd suggest there was no drug taking ever in this circumstance. But I can tell you that no one knew they were working those hours because their roster was specifically removed from the general population to see. So we become aware of it at the end of the situation when obviously the pay dockets went through. We were informed. So that to me is a fatigue issue. It couldn't be addressed by any random testing, I would suggest, unless every day they came to work they went through, say, follow the bouncing number or follow the dots around, which is the only thing I'd suggest. So.
But I think Mark raises a really good point too. Became aware of it at the end. And I think that's the dominant feeling across the majority of the industrial sectors who have to grapple with this, which I would like to wager is everyone, whether it's dealing with the consequences of it or dealing with it in real time on a shop floor in a range of sectors. The reality is that because compassionate healthcare, and when I say compassionate healthcare, it's not just about drugs, alcohol and gambling, it's about mental health. It's about fatigue. It's about, a range of issues to deal with impairment. Because those conscious conversations are not being had on shop floors across the state, from public to private sector, the reality is that union officials, but also employers, we're finding out about potential issues far too late. The other thing too is, when we talk about employers, and I think about the new federal laws that have come down saying that employers now have the onus to provide a safe workplace free of sexual assault, that onus now sits on employers. I, of course, emphatically agree with that, but I come from the mental health, disability and drug and alcohol sector, yeah? So I also know that there are a range of employers, good employers, who want to do the right thing, who actually haven't been supported to provide that because they haven't been funded to do so. And without funding, they can't provide it. So I would say there are a lot of employers who are in that boat as well, whether it's about funding, but also whether it's about support. And so any mechanisms we can do to link up employers, whether public or private, with the leaders in the sector, Odyssey House, Windana, Turning Point, to get educational programs together, whether it's checklists, industrial frameworks, working with each sector. We need to make it accessible wherever we can, I think.
And if I could answer to your question, people work because they've got bills to pay, and if there's an overtime shift and they're trying to get a new set of braces for their kid, they do those shifts. If there weren't these financial pressures on workers, we wouldn't have to mandate that they're only allowed to work 13 days straight. And then when you find them working 18 and 20 days straight, they crack the shits at the union for enforcing the law. That if you think that as a worker, particularly a man, gets older and has to admit to himself and his colleagues that his body cannot keep up with the strenuous job for fear of losing their job because the inherent requirements of their job, people get, doctored out, where they get, we are pretty naive if we do not realise that these are the pressures that working people face every day. That workers can get independently medical assessed who have done a knee 15 years ago, never had a day off for their knee, and get TPD'd out because they may potentially cause a risk in the future, and they've got two choices: to rock up to VCAT doing cartwheels saying I'm fine with no guarantee, where if they lose then they go to their TP and D and they go, well, hang on, over there you said you were fine and now you're here saying you're crippled, we don't give you any money. Like, that is simply the reality that we face every day. That is the carnage that we deal with every day. And that is the reality of the working world for a lot of people. So yes, that people do take a hit.
One last one to close from myself is something I just triggered to a memory here is that in terms of occupational health and safety, which we're talking about here, most reps will do a 5-day course and an annual type refresher. There is no requirement for anyone in management at the coalface, shall we say, up to senior management to do any sort of occupational health and safety course. So you'll find that from the grassroots up to the senior manager, they have no understanding of what the requirements are for OH&S, which is a really big issue here, because if we're talking about maintaining fatigue, they've had no training. And so that to me is something that probably should be linked back to WorkSafe to make it mandatory to do at least a 1-day course, if not a 2. And that's where I'd leave it.
Thank you. Renee, you done?
I actually did have one other question, but do I have time? No issue with
far away for you. I'll put it up.
There were just a few things that were said that I thought, it is concerning and it might point to a bigger issue. But Stephanie, you said that a lot of employees sort of tap each other on the shoulder and say, why don't you try, for instance, ice? It will leave quicker. How prevalent is this? How often is that happening?
So I think then the issue is, I would love to be able to adequately answer your question, but the reality is I can't because, and it points to a larger issue in that, I think given our role at being the union for mental health workers, and certainly our branch secretary being a former mental health nurse of 26 years, many mental health nurses and clinicians working at our union, what tends to happen is that employers from a range of sectors, including our own, but also more and more, other unions, whether it's, from a range of sectors, call and ask us for advice because these are the stories we get told. But also on the second point is that when we go out and we are routinely out with our mental health workers in inpatient units and community teams, when, you go through, you go for your members meeting, you talk about who's admitted at the moment. These are the stories we're hearing more and more and more. This patient.
So sorry to interrupt, but I just want to know, how often would those conversations occur? Once a day, twice a day?
Multiple times a week, I would say.
You only have to talk to the general public when they talk about AFL testing regime, and they say, "Well, why would everyone says it? Why wouldn't you just be able to do a bit of coke on it? After the game, you by the Monday, it's out of your system.
Peptides.
Peptide. People know
whatever it takes.
Yeah, people know out in the community. People know that weed is in your system for up to 6 weeks. People just know it.
So bring it back to the terms of reference in terms of
that's
the medically prescribed cannabis. Just not on this point. From our point of view, it's anecdotal, but it's exactly what they're saying is if there's, everyone takes, not everyone, I have to withdraw that. Recreational drugs is common, in the community, it's there. But if you talk to people and it's a drug of choice between cannabis, whether it's social, recreational, medically prescribed, and then a drug of choice where it can be out of your system in a day and you can get to work and not risk your employment, that's the type of comments that we also hear. So the problem is the attitude to cannabis and the punishment as well in terms of the risk.
Yeah, and how often, another thing Stephanie said is about how they often people will adapt work. I just can't find where I wrote it down. They adjust the work because of impairment. Is that with medicalised cannabis, and how often does that happen?
So it doesn't happen at present, but it's what we would like to see happen. So we would like to see reasonable adjustments to work. So in an ideal world, I would have a disability worker, for example, working in supported independent living, call their organiser and say, hey, I've got a bung shoulder and the doctor said I've got a Medcam prescription. Can you come with me to talk to the HR manager and the CEO. Yep, no worries. So in my ideal world, I'd love to be able to sit there as an organiser. You know, if I had access to some sort of worker-led drug and alcohol worker, I would love to pull in that knowledge and expertise as well. But I would love to be sitting there, union, AOD worker, if necessary, the worker and the employer to come up with what reasonable adjustment looks like. It's for me, it's no different from when we've got workers who are returning to work after seeking the assistance of perhaps going to rehab. Oftentimes we'll get a supported work plan, that can be presented to the workplace if that workplace is open to those conversations where, we've got reasonable adjustments laid out. We've got, I hesitate to say consequences, but what do we do if someone's feeling a bit shaky? Who's our support person? It's those conversations we want to have happening.
That's with general drug addiction, though, not with medicalised cannabis. Because would you agree that with medicalised cannabis, we'd want to treat that without any stigma?
Absolutely.
Without any door on drugs, if they're taking a legitimate medication. So I'm just finding that this conversation, I'm trying to separate the bundling with illicit drug use. Wouldn't you just treat medicalised cannabis like a person with that the same as you would treat anyone else that is going through a health?
100% yes.
Yeah, okay.
100% yes, but I think from all, and I don't want to speak for my other colleagues here, but I think the reality that we face on all work sites is that's simply not the case for any drugs, alcohol, or gambling, whether it's illicit, whatever it might be. We don't live in a framework where that feels possible at the moment.
If I could supplement that answer, the terms of reference speaks about drug testing in general. It asks about legislative framework in general, and it also speaks about roadside assistance. In terms of the direct question you just asked, Stephanie, I would say that for the longest time for impairment, there has been reasonable adjustments made. Just like the story I told you when I was 18 years old and they put me in a sick bed for 2 hours and I got up and did my job and worked there for another 10 years, right? Just like when somebody says, I've got this thing, I'm on this opioid, it says I shouldn't be driving heavy machinery, that a boss may say, okay, well, you can work on SOPs, safe operating procedures. That's a reasonable medical adjustment. Now, I can't answer in relation to medical cannabis because I'm not an expert on the impairment that prescribes, but I dare say a doctor would be, not I.
Well, thank you, Renee. Just running over time. Just before, I think Ryan's got one question. Mark, I just want to ask you that impairment testing machine, have you got more detail or we can get back to that?
I know in Queensland, I think, has had quite a lot of interaction with them. I've only read some of the documents, and the simple thing I would say is they used to have one where when you drive up to swipe into the gate, there'd be a screen there, a dot would pop up, you have to touch it, and you'd chase the dot around the screen. And that would be done every single day they drove in, as an example, on some sites. And what that would do is they've got an algorithm that allows it to see whether if you come at a different time, there's certain allowances for if you're tired. But it'll get to the point where if you don't get it right, it'll let you know, then, okay, you better be switched on, follow it right. And if it doesn't happen again or a second or third time, then you basically have to pull aside and talk to the person on site that'll decide face-to-face through their protocol whether to let you in. I think there were some other ones which relied on facial recognition which weren't that successful. That's the only ones I've really read about.
You said the ones that you're studying in the UK at the moment.
The ones in the UK, that was about what looks like a COVID test. That's a fingerprint testing.
Yep.
That can be used for no matter what people are doing. Apparently you can't, because your fingers sweat.
Yep.
That's one that's very stable.
Yep. So do you have any information on that?
I do.
We can get it on notice.
Victorian Trades Hall Council has put a submission, I believe. I thought it was to this inquiry. It might be a similar one. I think it's Ted. Is it Ted from memory? And I gave him the documentation to follow it up, and I believe it's going through trials to prove it now.
Okay, thank you. Just before I pass on to Ryan, so one question I asked you about rehab. Heard you mention about all this awareness, all these lessons. Here's all the time. Because I'm not too sure you know about mandatory training with the Army. They do this every year, and they go through all the process. So or maybe you have a look at that, because we've actually gone through all gamblings, drugs, stress, heat, self-awareness, identification. So it's something when you mentioned, I did it just to trigger because I train all the officers that way.
I think, unfortunately, Fitzgibbon's parachute, not his packing group, but the other group was pulled up just recently about that too.
So it's exactly all the process. It's actually a day's course, and they go various different topics. So it's mandatory training. They do it every year. And so, Ryan?
Just very briefly, you mentioned a couple of times that what should happen next with identifying people with drug addiction problems through a testing regime. I think AMW mentioned in your submission the kind of rehab services that we needed to get. Probably don't have the time to go into detail now, but if you can provide us on notice the sort of your assessment of current state and what options there are to improve drug rehabilitation services for workers, I think the committee would value any of that information.
Okay, fantastic, can do.
Just on the fatigue question you asked, there was also another bit of software. There's numerous software, but there's one called FAID, F-A-I-D. That was fatigue, accident, incident, something or other. You used to be able to download for free and install it. Now, that was one where you put in your rosters, and it made the assumption that the person would get, say, 6 or 8 hours sleep. You'd have to adjust that for the individual, and that would give you an equivalency of 0.05 type relations, and that has been used, I believe, in court many years ago, but not across the details recently.
Thank you. David, do you want to ask them a
Yeah,
question
I
on
think
notice?
we're at that questions on notice type stage because we're obviously getting late in the day. There was a couple I'd just like to respond to. Mr. Jacka, you talked about the Disability Discrimination Act and the potential effect of that applying to medicinal cannabis. I wonder if we could just put a question on notice to you, if you could just elaborate on whether you think there should be reform or amendment to the Discrimination Act to clarify its applicability to an industrial setting, a workplace setting.
I will. I'll take that on notice, and I think the
that's what I'm asking.
Victorian Discrimination Commission's also made a submission and suggested some wording that I can't tell you off the top of my head, but I'll come back to you on that.
I think we'd love to get an industrial perspective on that. You also referred to the submission from the Lambert Institute, or the Lambert Initiative, and Professor McGregor. Heaven forbid I ask a group of union officials whether you'd agree to something or not, so perhaps on a without prejudice basis. The Lambert Initiative submission refers to the concept of cocktailing both a swab type test with a Druid style test. So you have one that tests for presence and one that tests for impairment. And unless you fail both, then you fail none. And I guess I'd be interested in, again, from any or
On a without prejudice basis, I'm not aware of the actual impairment side of the test, but I would say in general, if an impairment process is in there and it passes the test, I'd suggest that would be a better process than we've got at the moment.
I'm going to put these on question on
yeah,
notice
yeah,
if that's
yeah.
possible, and we'll just go from there. Ms. Dewson, the Haxley submission, fabulous, really comprehensive, so thank you for that. I just, again, putting in a question on notice, you made a comment about getting laws and industrial rights, getting laws and industrial frameworks right. I guess from a committee point of view, we'd be interested in terms of the learnings you had from America and from Canada, if, as lawmakers, we would be very interested in your thoughts as to specifically what you think this inquiry could be recommending.
Okay.
Based on those learnings, that'd be fantastic. That'll do. Thank you, Chair.
Rachel, any question on notice?
I was just actually wanting to talk about the employees example that that Adam had referred to, and sorry,
Mark.
Thank you, Mark. Sorry, I should put my glasses on. Just quickly, all the employees that you refer to here had disclosed medicinal cannabis, and that meant that they were stood down and then investigated. If it was a different medication that they were disclosed, do you expect that there would be a different outcome?
Yes. Well, almost 100% yes.
Right.
Yeah.
So a medical defence is afforded to, say, an opioid-based medication for pain relief, but not medicinal cannabis for pain relief?
The problem that we'd experienced was that, and just to start with, each one of these employees followed the policy and procedure to a T.
Yes.
And treated it as if it was prescription medication.
Yeah.
Whereas I can't exactly remember the other medications that they were on to treat this medical condition, but there was no issue with them coming to work, having that prescription medication, so long as they had a consult with the doctor, got it prescribed, and followed whatever guidance came with that. So, for example, if it said, this may cause drowsiness or whatever that might mean, then the employee had an obligation coming to the impairment point to either say, hey, I'm not feeling right or whatever, but there was no problem with that prescription medication. But when it came to medically prescribed cannabis, the blanket position is no, not at all, despite them following the process.
Thank you.
All right, on that note, I want to say thank you so much all for coming in and impart your knowledge and your experience, and definitely representing a large cohort, different sectors. I understand the essential relation to heavy machinery and various different type of manufacturing workers as well. So thank you so much for your insight, and I hope those questions and notice you put forward to us, and we'll definitely take into consideration relation for recommendations.
The questions I noticed, is there a time frame? Is it how quickly would
2 weeks.
2
weeks.
weeks.
Okay.
It's all
All right.
good to you.
To know.
And hopefully, insights with mandatory training will help you listen to assist in the training with your staff as well. So that's not. Again, thank you so much for coming.
Thank you.
Media.
Thank you.
Thank you.
What else? The
Thank you.
cancer